Okay, so now it should come up with a little button that says you have to approve that, you know that it's being recorded. So if you have that, just go ahead and click on that. That'll be great. Okay, so I'm going to share my screen real quickly so that I can just introduce myself. I'm sorry, go ahead, Amanda, you go ahead.
That's okay.
I'm used to the library, so being in person, so go ahead.
All right, so thank you so much for joining us for today's senior series workshop, The Truth About Wills, Trusts, and Probate. We've worked with Liz McNeil for a long time, and she gives great presentations. Let me just briefly introduce her. Liz McNeil is a realtor and a downsizing coach with the passion to serve as a dedicated partner throughout the consultative process surrounding a late in life move. Her mission is to help older adults and their families understand all their options so they make informed decisions. She holds the Certified Senior Housing Professional designation, which is a doctorate-led program within the Seniors Real Estate Institute. As a SHP, she has networked with a team of trusted professionals to provide top-level expertise at her seminars. So please welcome Liz McNeil.
Thank you so much. I will just share my screen real quickly. I appreciate that. I see Mr. Condor waving, so thank you for that. I'm going to share this real quickly because it will just give you our contact information. And let me get to that real quickly. I'll tell you a little bit about the seminar series, and then we will talk a little bit about Mr. Klevenhagen, our wonderful attorney who is gracing us with his presence today. Okay, can y'all see that?
Yes.
Okay. So as Amanda said, my name is Liz McNeil, and I founded the Houston Senior Living Series 5 years ago so that we could get this information out to all of you. And I have been doing them in person at the university library. And of course, everything changed last year. So we've been trying to do them virtually. And we were supposed to have this seminar, this legal seminar back in May, but due to an emergency that happened, we unfortunately, some of you may have been online and we had to cancel. Christina was definitely under the gun that day. But we're back now, and we have a wonderful attorney who is going to, I'll just put this here, that's me, but you all know me. Well, let me go back and tell you that, as Amanda said also, I am a community resource. So if you have any questions about anything in our seminars or outside of the seminars, if you have some questions, you can always reach out to me. And if I don't know the answer, I know where to go and get it for you. And that's real estate related or not. I am a realtor, and I do work all over Houston with clients of all ages. And then I also have this specialty division, as Amanda said, of working with clients, making decisions about late in life moves. So that is me. And I did not have a picture of Mr. Klevenhagen. So JJ, I didn't have your picture, so it's not there. But if you would, any of you would like to jot this information down, this is how you would be able to get in touch with JJ. And he's going to, at the end of the seminar, when we finish up at the end, I will put this back up, both of our information, so you can jot down any contact information that you need. So now I'm going to get out of this and I'll go back to that. And
Liz, I'll also type that in the chat just in case they want to copy and paste it from there.
Okay. Do you have it? Did you get it?
I have your information in my email. I think
okay.
I have his too. I'll look it up.
Okay, perfect. Okay, so we are graced again with Mr. John J. Klevenhagen III today, whose specialty, one of his specialties, let's see, is, dagnabbit, this is hard for me to read. He does work with civil and probate litigation, and he's going to tell us more, please, because I'm not good at reading your resume that you sent me. So I will introduce you as Mr. John J. Klevenhagen III, and he is going to help us with some information. I'm going to ask him some questions like I always do in my seminars, and then if you have questions, you can reach out and raise your hand, and we'll get to those too. So thank you so much for being with us. We appreciate it.
That's great. Liz, can everybody hear me?
Yes.
Yeah. Yes. Okay, good. Well, thank you for logging in this morning. Hopefully we can provide you some useful information. I've been practicing for a long time in the areas of probate and trust and guardianship and probate litigation. So hopefully we can sort of at least cover the basics. Of course, some of those topics, they have seminars for lawyers that go on for several days just on some of those topics. So, obviously we can't cover everything, but I appreciate you guys letting me speak with you this morning. And also, I would be remiss if I didn't point out that I office with a lawyer named Anna Lee May. She's a great attorney who also practices in this area. And we were planning to do this together this morning for all of you, but unfortunately she had a funeral come up. So you're stuck with just me, but we will plod on and see if we can provide you a little bit of useful information. So Liz, do you want to throw out a question and I can discuss it, or you want me to kind of give just a basic overview of probate, or how should we start?
Well, we'll start with that. We'll just kind of talk. We can talk about probate, but then I do have those questions that I sent you that are, one things that we do want to talk about. I'm going to ask if I mute everyone. I'm going to mute everyone so we don't have any background noise. So I'm going to do that. And then JJ and Amanda, you'll just have to unmute yourselves. Okay, so everybody's muted, and now you can just Amanda and JJ. There you go. Thank you. Okay, so we will talk about that, about probate. That is so important. And but I wanted to just kind of ask you a couple of questions.
Sure.
About just to start out with the really easy question. I usually, if we were in our seminar in person, I would ask everyone to raise their hand who doesn't have a will or who does have a will. And it's amazing what we get with that. It's how many people don't have a will. So I like to start out with that, about what are the consequences of passing, any of us, whether we're 85 or 25, what are the consequences of us passing away without a will?
Yeah, so I mean, I do a lot of wills for people. It's not typically the kind of thing you want to think about or kind of conversation you want to drive over to a lawyer's office and sit down and have, but it can be a very important one. I mean, really what you're doing when you're doing a will or any other estate planning is you're making things easier on your family, or who's going to be taking care of your estate, because you're not there anymore. So quite frankly, really it's for those that are still around after you pass away. But if you die without a will, that doesn't mean that your estate doesn't get probated and administrated. It just means it gets done in a different way. And the short answer to the question is, it's probably a little more time consuming and a little more expensive in terms of attorney time to probate an estate without a will.
So what I'm hearing then is that there probably funds would be taken out of the estate, maybe whatever, to have to pay for that probate, to take care of that. And we're looking at it can be quite a large sum of money to take care of that. Is that right?
That's right. Typically, and it just depends on how things are set up, and I don't want to get too much, into the detail at this point, but usually, well, it kind of depends on the lawyer that you visit with and what the lawyer is willing to do in terms of outlaying the cost. So in order to open an estate with or without a will, typically you would go to an attorney. The attorney would draft the legal documents, the pleadings that would be filed in the probate court. Here in Harris County, there are 4 what are called statutory probate courts that do all the probate in Harris County. Other counties that aren't as big as the major cities don't have dedicated probate courts. So they have courts that sort of do everything. But wherever you are, there is a filing fee associated with filing the documents to open the estate. And then if you're hiring an attorney, there's cost for the attorney. And sometimes there is money accessible from the estate of the person at that time, but sometimes there's not. If you pass away and you're the only one on your bank accounts and there's no provision for anyone else to sign on those accounts, then your heirs or your family or whoever would be trying to take care of the estate may need to come up with those costs on the front end. Now they would be entitled to be reimbursed from the estate at some point. But yeah, so a little more expensive, a little more time involved with dying without a will. If you die without a will, it's called an administration. And there's, like I say, there's a few more steps, and the court has to determine who your heirs are and appoint someone to be in charge of the estate, things like that.
If any of you, I see, like I said, we're up to 71 people now. If any of you have ever been to any of my seminars, you know that I bring some levity into it. And I always say in almost every seminar that statistics prove that none of us are going to get out of this life alive. So it's in our best interest, but it's really in our family's best interest to have a will. Isn't that right?
That's right. Like I said, you're gone, so you're not dealing with it. But the will, well, obviously the will directs exactly how you want your estate to be devised. So it carries out your wishes, of course. And then it simplifies things for a person who is in charge of your estate under a will is called an executor, and that's somebody that you name in your will. And it's typically less expensive, less time consuming, and less involved for an attorney to go probate a will to take care of your estate, as opposed to dealing with an administration without a will.
Well, tell us a little bit about who needs a will. If I don't own any property, if I am retired and I have my Social Security that comes in every month and I live in an apartment, I don't own any stocks or bonds or oil and gas rights. I don't have anything like that. Do I need a will, or how can I handle that differently?
It's a good question. So there are certain assets that are called non-probate assets. Those are typically assets like an insurance payout, a 401k, an IRA, where you have usually designated a beneficiary to those accounts. It could also be a bank account, and I think we'll talk about this maybe in a minute, that might be designated excuse me, as payable on death. But if you have an asset that you have a contractual relationship with a financial institution, like an insurance company or a bank or a brokerage account, brokerage firm, then those assets pass outside of the probate process. Even if they were named in your will, the will does not control if you have a person or entity designated as a beneficiary with that institution. So now it's, if you want to be, thorough, then my answer would be everyone should have a will, because there could be some asset out there that you forgot about. There could be some asset that comes to you or your estate even after you pass away that would not have been accounted for. So it's almost kind of like some insurance in a way that it just guarantees that your estate, whatever it may be, even if you have a lot of other things designated, is going to pass exactly how you want it to pass.
Well, how about what you mentioned about beneficiaries? And if you have a beneficiary for, like you say, a 401k or retirement account, whatever's going on there, and then also your bank account. And I know my husband and I have on all of our assets, because we were blessed with one son, one child. So all of everything that we have, he's the beneficiary, the second beneficiary. So if something happens to us, he doesn't have to deal with anything but to go and say, here I am, here's the death certificate. And, I have access to the bank account, all the funds and all that. So that's really important to have beneficiaries named on all of those assets, isn't it?
It is. And anytime you're considering any kind of estate planning or getting a will for the first time, or reviewing your will that you have done, I always recommend that people review all those accounts and get in touch with every financial institution and ask them for a copy of your designated beneficiary form, because sometimes we make those designations maybe at a time before we had kids, or families change over time, and you just want to make sure that those beneficiaries are who you want them to be.
Okay, and you say that, and that reminds me also that another thing is that when I started doing all these seminars, I realized this, and the last time my husband and I had looked at our will was when our son left for college, and we had revised everything, showed everything to him, and that he's now 39 years old. And so once I started doing this and realized I needed to have everything revised and reviewed and revised if it was necessary. But it's important to have that reviewed. What kind of time frame do you look at? Do you like every 3 to 5 years, you just need to kind of review it and go over everything?
I generally tell my clients about every 5 years, just review everything, because families change, circumstances change, financial positions change, and it's just a good idea to kind of review that. I say about every 5 years, but 3 to 5 years would be perfect.
Well, what do you do if you don't have any family at that point? Another story, I always have stories, but I have a client who I'm helping her sell her home now, and she's 89 years old, and she doesn't have anyone at all. And so to make as a power of attorney, all of her friends and family have passed away before her. And so she doesn't have anyone to name as an executor of her estate. And she has a pretty good size estate. And I'm helping her sell her home. So she asked me, she said, because you have so much knowledge in the senior world and you do all of this, could you be my executor? And of course I told her no, that wouldn't be appropriate. And that there are people that do that on a basis, a public basis. They're, what do you call them? I can't remember now. Someone who would be an executor of an estate, you would pay them a fee to do that, right?
Right. And that can all be, specified in the will. I mean, you get to name who you would want to be the executor. We usually recommend a backup in case that person's not available or decides they don't want to do it. Ultimately, a financial institution like a bank, a lot of times banks will serve as trustees if there's, a trust involved or things of that nature. But banks can be listed as that in that capacity as well. And those are institutions that would be paid. Usually, well, sometimes if they're managing a trust, it has to do with the percentage of the assets, but an executor, it could be a flat fee or it could be an hourly, compensation arrangement that would be paid out of the estate.
Okay. I see that we have 2 hands up, so I'm going to check. Let's see, I've got Amanda and Neil, I think it is. So do y'all have some questions?
We had 2 come in via the chat. The first one was, do you also cover any assets, property, and money abroad when drafting a will or trust?
Ooh, that's a great question.
It is a good question. So your will in most states in the United States have very similar requirements for a will to be a valid will. And so if you move around, again, if you did a will in Texas and you move to another state, typically the law is that the estate needs to be opened either where your primary residence is or where you died. So you would want to visit with an attorney in the new state and show that attorney your will and see if it qualifies in that state as a will, and then it might not need to be changed. But a will is in a will, you can make what's called specific bequests, where you basically line item it by asset. I want this asset to be devised to this person or these people. And then there's what's called the residuary estate, which is kind of everything else. I want the rest of my estate that's not otherwise named specifically to go to this person or these people. A will probated in Texas will cover all real property in the state of Texas and all personal property wherever it is. Now, if you have real property in another state, for example, typically what you need to do is open kind of an abbreviated, what we would call an ancillary probate proceeding in that state. And it would sort of be kind of like a subsidiary of your main estate in Texas, and you would likely, work with an attorney in whatever that state is where you own that real property. And the reason for that is a Texas probate court does not have jurisdiction over real property in another state. So you would need to go to that state and get like an ancillary probate proceeding to legally transfer title to that property. And really the same thing for a foreign country. A will here is not going to cover real property in a foreign country. You could, I suppose, create another will that would simply cover, according to the laws of that country, that would cover whatever property you have in that country, or it would be the same kind of procedure. You would open an ancillary proceeding in that country, and then you get into, there's a thing called the Hague Convention, and it's like an agreement that most of the countries in the world have signed off on how to kind of deal with out of country legal issues. But yeah, that would most likely involve getting a lawyer from whatever country that is involved to take care of something in another country as well.
Okay, and the second question was, can you name a minor as a beneficiary? For example, what if the kid is still a minor?
You can name anyone you want. As a beneficiary, yes, absolutely. You can name a minor as a beneficiary. What most people do, as long as they have minor children, is they include a trust in the will, and so the trust comes about as a result of the will, and it's called a testamentary trust. And the reason why they do that is because if a minor were to be a devisee under a will, the minor would not be able to legally receive whatever that asset is. And absent a trust, the probate court would probably force whoever the guardian is of that minor to create a guardianship for the minor that the court has oversight of, so that there is some, legal protection for the minor, and somebody doesn't, the minor can't, manage that asset, and B, the court wants to make sure there's protection so that someone doesn't, take advantage of the minor. And even though that minor has parents, the court in a situation like that is likely going to still require a legal guardianship provision, so the court has oversight over that asset as it relates to the minor. And that would require a person to be the guardian of that minor for that asset and regularly, annually, account to the court for what's going on with that asset and things of that nature. So yes, you can name a minor. If the minor, turns 18 before the gift is made or the devise is made, then it goes directly to that person because they're not a minor anymore. And that's, so like I said, if you have minor children or minors that you're considering being devisees under your will, it's a good idea to include a trust. So that way it goes to the trust for the benefit of the minor. And then you pick, just like you name an executor in your will to be in charge of your estate, you name the person or people you want to be in charge of that trust. Can be the same person, can be a different person.
Okay, how about Neil? You had a question?
The question is for JJ, I guess, or should we call you John? It's a very rudimentary, basic question. I heard sentences like, probate a will probated in Texas. What does probate a will or a will probated in Texas? What does that mean? Like, in layman's
so
terms, being
That's a
non-legal
good
people?
question.
Yeah.
So probate is, I guess, kind of a general term that is sort of includes estates, either with a will or without a will. Sometimes people would include trusts under kind of the heading of probate. Sometimes people would include guardianships under the heading of probate. And that's partly because, like I said, there are some statutory probate courts that deal with all that, and those are all the things that they deal with. Opening a probate could be with a will, could be without a will. Probating a will means that you have filed a document in a probate court along with the will, asking the judge of that court to review the will, declare that it's a valid will, and open up a case in that court's docket, which would be the probate of the estate. And then in that case, the executor of the estate would be responsible for filing whatever needs to be filed depending on the nature of the estate. Usually you file the will, you ask the court to probate it, you have a hearing. If the court finds everything in order, the court signs an order admitting the will to probate, meaning it's declared that this is the will. The court signs an order naming the person who's asking to be the executor as the executor. And then the executor has the authority from there to go do what they need to do with the estate, which is usually collecting the assets of the estate, and then taking care of any creditors that may be out there, taxes, loans, mortgages, things like that. And then ultimately distributing the estate in accordance with the terms of the will. And there's a few steps depending on the estate in there before final distribution of everything. And typically that includes filing what we call an inventory, which is a listing of the deceased person's assets at the time that they passed away.
Okay.
Notifying persons named in the will that the estate has been opened and sending a copy of the will and things like that.
I see. Okay, thank you. Thank you for enlightening me.
And we had 2 more come in the comments. Liz, do you want to do those now or later?
We can do that real quickly. The one, I see that one where they ask if you have to be a resident of Texas in order to be an executor of an estate in Texas.
You don't. The only thing is you have to have a registered agent who is in Texas on your behalf. And usually what happens is if the executor lives out of state, and we do this all the time, they still file for the probate just like anyone else. And they usually name the attorney that they've hired to be their agent. And the reason for that is just like a company has a registered agent. If they were to be sued or someone needed to make a claim against the estate, they need to have someone in Texas that they can serve with that. And so 99 times out of 100, the lawyer who's filing the paperwork and opening up the estate files a form that just says this out-of-state person is designating the lawyer as their Texas agent.
That makes sense. I just had one that I helped some people, with selling their house, and they're in Florida. The executor was in Florida, but the attorney is here.
Right.
And so, that makes sense that you have to have legal representation in this state. There's another question, and this is a good one. Is there a way to avoid probate? There are no dependents or minors. I only have a spouse. So tell us a little bit about that.
Yeah. So really avoiding probate kind of depends on the assets. And the most important assets that you need to take care of is real property, because, to transfer ownership or title to real property, someone with legal authority has to sign a deed, right? So if you pass away, and this is very common, so husband and wife, they both own their house, and there's community property and separate property that gets involved in this some too. But you know, the law says that if it's a community property house, which most of the time it is, then when the first spouse dies, each spouse owns half of the real property. When the first spouse dies, that half goes to the other spouse, usually. And that doesn't, in and of itself, you know, sometimes people run into problems because, let's say, you know, husband and wife, they've lived in the same house forever. There's no mortgage owed or anything. And so the first spouse passes away and they're, you know, they're all joint bank accounts. There was, you know, just there are things in the house and there's really no need at that time, seemingly, you know, to open up a probate because the surviving spouse just continues to live in the house like they always did and they don't think about it. And then, you know, the issue arises when the second spouse dies. And this happens especially when there's no will. Now the heirs are, you know, trying to figure out, okay, well, you know, we're inheriting this property, but so we open up an estate for the second spouse, but we realize, and it usually comes up, and Liz, you may have seen this, when it doesn't come up until somebody wants to sell the property. And this could be, they could be years apart. So the first spouse could die a decade before the second spouse, and no one did any probate for the first spouse because it didn't seem like there was a need to. Now, the heirs, the children, or whoever are trying to sell this property, and they realize, okay, well, we did an estate for our second parent, and so that person's half passes to us, but we don't have anyone to sign on behalf of the first parent. We never did an estate. We never opened anything up for the first parent who died 10 years ago. And so now we've got to go back and do an estate for the first parent so that we can pass that parent's half to the second parent. And then we can pass 100% of the house to us so we can sell it, or so that the state can sell it. So that's something that comes up sometimes, and it's usually not an insurmountable issue, but if there's been quite a period of time, it can make things more difficult, and it can certainly drag out the process and be a surprise. But I think, to answer the question, it kind of depends on the assets that need to be passed as to whether you really need a probate or not. Also, with respect to the real property, you can execute a transfer on death deed, which is a specialized deed that basically says, when I pass away, I want my interest in this property to go to whoever. So in that example that I gave, if both spouses had executed a transfer on death deed, then when the first one passes, just by operation of law and by the fact that if that deed was properly drafted, signed, and recorded in the real property records, then that community half would automatically pass to the second spouse. And then you would kind of avoid that issue. And then that second spouse, that would be a time where you would kind of reevaluate your estate planning, and you would, if your transfer on death deed didn't already say this, then perhaps that second surviving spouse would execute a new transfer on death deed, that now they are 100% owner of the property, and they would say, okay, now when I pass away, I want the property to go to my children in equal shares, or whatever the case may be. Now, there is one caveat with a transfer on death deed. That under Texas law, the statute that creates the transfer on death deed provides that there is a look back period for creditors. And I think it's 2 years, if I'm not mistaken. I'd have to go back and look at that statute, but Liz, you may have come across this as well. And so the issue that you sometimes run into with a transfer on death deed that you would not typically run into with an opening an estate, whether it's with or without a will, is that a title company won't want to issue a title policy to sell that property until that time frame is passed, because that look back period gives creditors of the estate of the person who creditors, people that would claim that they're owed money by that person before they died, it gives the ability for creditors to go back and make a claim against the asset, that asset. Really it's a claim against the person for owing money, but it would be backed by that real property asset. And so that's just my experience is some title companies will satisfy themselves that they don't believe there's any creditors out there, and sometimes we'll go ahead and issue a policy and allow the sale to go forward, but other title companies are not willing to do that. So that's just one little caveat to keep in mind if you are planning on using a transfer on death deed.
I think transfer on death deeds are one of the nicest things that the state of Texas has done for people, because it can just help you and your family. I mean, your family, not you, because you'll be gone, but it can help your family so much by making it so easy to make
If
that,
you had,
transfer.
if it was your house, you have one piece of real property, your house, and you have a couple of bank accounts, you can, go to the bank and sign a form that says, I want to designate these bank accounts as payable on death. So on my death, I want you to transfer this bank account to this person or these people. You sign a transfer on death deed, and then literally you've taken care of all your assets. Now, like I said, it's happened before. Sometimes there are assets out there that you don't remember or you don't even know about. Perhaps, a relative passes away after you passed away, and you are a devisee of that person's will or an heir of their estate. The most common thing I've seen with that, where an asset shows up later, is an oil and gas interest. Sometimes people lose track of those, or the oil and gas company isn't sure who the right, person is to be paying oil and gas royalties, so they'll be holding them in suspense until they can figure it out. And it happens. It's not often, but it happens.
I think one of the things, and we're going to get to some more questions in just a second, but one of the things also that comes into play, which I have experienced this with my own clients, and not everybody on here will relate to this, but if it's a blended family,
right,
and there's mom and dad and they have children, but mom has children from a previous marriage, or dad does, however it is, blended, and then without a will, it becomes a real problem as far as what happens when you've got, like I said, we don't have to touch too much on it, but that's when it's really important to have this all spelled out and taken care of ahead of time. Otherwise, you can create a perfect storm.
Yeah, it's almost imperative that if you have a blended family, you sit down with your spouse and you guys get on the same page and you go get a will. If you want things to be done the way you want them to be done, that's really, really important, because as described earlier, I do a lot of probate litigation as well, and I will tell you that most estates that involve litigation have to do with blended families.
I would think so too. And I'm going to ask you more about that, but let's get Mr. Bannon's question. You have a question, sir? You're right. Let me see. I can unmute you. Let me see if I can help you. Okay, now you should have a button to just push that, unmute. See it? There you
Okay.
go. Okay, we got
Okay. All right. Anyway, I have a daughter who is a PWD, and I'm interested with the living trusts. Is this a part of this seminar, or is it a big discussion again?
Yeah, so trust is kind of part of the probate world. There's typically two kinds of trusts. There's what I called earlier a testamentary trust, which is a trust that doesn't get created until you pass away and your will gets probated. It's spelled out in the will and it's created in the will. The other kind of trust is an inter vivos trust, and that's kind of Latin that just means like now in life. And so that's a trust. A trust gets created by a document that's usually drafted by an attorney that spells out all the terms of the trust. And really, to have a trust, you need a trustee, you need beneficiaries of the trust, and then you need to fund the trust with something. That's another, kind of part of the estate planning process and probate planning process. There's a lot of reasons that that people might want to create a trust. Sometimes it's asset protection, sometimes it's estate planning. Yeah, I mean, again, there's seminars that go on for days on trusts. So we can't cover everything about trusts, but yes, in general, that's kind of part of the probate and estate planning process. And it's just a good idea to visit with an attorney and see if that's something that that you really need. I mean, I do see people sometimes they hear about trusts or think they know a little bit about trusts. And sometimes, I advise people that they probably don't need a trust, because when you have a trust, typically that's, you're going to need it kind of becomes its own legal entity, and it's going to need a tax return filed every year and things of that nature. So it's different for everyone.
All right, thank you.
Mhm.
So we could do a whole class on trust is what a whole seminar on trust.
We could, yeah.
Amanda, did you have another one? I see these other ones in here, but did you have something else?
Yes, I had two that were sent directly to me. If there is no will, does the court require a bond for the executor or administrator of the estate?
Good question. Sometimes. And a will can require a bond as well. Usually, if you're doing a will, you put in the will that no bond is required for the executor. But if the will does not specify that, then the court may very well require a bond. But that's, certainly unusual with a will. If you don't have a will, then you're opening up an administration. And there's two different kinds of administration. There is a independent administration, and there is a dependent administration. And the main difference is the court oversight and involvement regarding those estates. If you have an independent administration, the court has very little oversight and very little involvement. Basically, once the court grants the administration and names the administrator, then there's no bond. And from there on, it's almost just like having a will. You have to file the inventory and a few other things. It's a little more work on the front end. And there's typically no bond required with an independent administration. The way you get an independent administration is to get all of the people who would be involved in the estate, basically all of the heirs, to agree in writing, and usually by signing a sworn declaration, and say, I'm an heir of this estate. I understand that my sister, my brother, my mom, whoever is applying to be in charge of the estate as the administrator. I agree with that. I approve of that. That's what I want to happen. And if all the people who are heirs of the estate sign off on that, then the court will grant an independent administration with no bond. If, however, you can't get everyone's agreement, or if there is a minor who is an heir, then the court will want to retain oversight of the estate. And it limits the authority and the ability of the administrator. There's still an administrator named, but the administrator pretty much has to go to the court and ask permission to do most things with the estate. And the court is almost always going to require a bond. And the amount of the bond will be set generally based on the value of the assets in the estate. Because what the court is wanting protection from is the person who they're naming as the administrator from running off with all the assets of the estate. So usually no bond with a will, no bond with an independent administration, but almost always a bond with a dependent administration.
Can you just quickly explain bond, just in case somebody doesn't know?
Right.
About it?
So a bond is kind of like an insurance policy. Usually people don't, if an estate has, a bank account with $100,000 in it, that's going to need to be distributed at some point after expenses and creditors are taken care of, then the court is going, and it's a dependent administration, the court is going to want some insurance that the person who the court is appointing doesn't just take that money and run. So that person, if they had $100,000 of their own money, they could go deposit that in the registry of the court and say, okay, Judge, I'm securing the assets of this estate with this cash bond that I'm posting, but that almost never happens. So what the person does instead is they go to a bonding company. It's kind of like a bail bond. A bail bond, if you were dealing with a criminal matter, you would go to a bonding company and the bonding company would write a bond, which is basically just a promise to the court that, look, this person's going to appear for their court date and I promise to pay, $10,000 if they don't. So in the probate world, a bond is kind of the same thing. You go to a bonding company, the bonding company takes your application, reviews you as an applicant, and decides whether they want to insure you or not, and most of the time they do. And so a premium gets paid to the bonding company that's far less than $100,000. And then the bonding company files a document with the court that says, okay, we are insuring this person as the administrator of this dependent estate. And if this person runs off with the money, then the heirs of the estate can come collect it from us. So it's basically insurance.
I'm sorry, excuse me for interrupting. Can the premium be paid by the estate or does the individual executor?
Yes, the premium can be paid by the estate, or at the very least can be reimbursed to the person who pays it out of the estate.
Okay. And we have a lot of questions coming up, but I want to just go back to these two because then we'll leave transfer on death deed behind. But two questions is, one, can you do one if there's a mortgage on the property? And the other question is, how do you revoke it? If you've done one and then you want to change that, how do you do that?
Yeah. So you can do it if there's a mortgage. Of course, it's any transfer that you make is going to be subject to that mortgage, and you're not going to be off the hook, or your estate's not going to be off the hook if there's money owed on that mortgage. That's going to, and then, if you were to pass away and there was a balance owed on the mortgage, it would be a matter of whether, the mortgage can make a claim against your estate and against that property, sort of like we were talking about earlier. And then either they could, your devisees or whoever you, devised it to could try to make an arrangement with that mortgage company to either refinance it or continue the payments or something under their name, or perhaps could go refinance it with a mortgage company and pay off that existing mortgage. But at that point, it's a little bit up to that mortgage company that's owed the money. If they don't want to work something out legally, they would have the right to, either collect that money from the estate, or if the estate doesn't have that money or is not willing to pay that off, then they can, foreclose on the property to get paid. They're going to get paid. So it's just a matter of kind of whether you can work something out with them, which sometimes they're willing to do.
Okay.
And
So,
revoking, yeah, the statute specifically says that you can revoke a transfer on death deed. The best way to do that would be to do it in writing and to file that in the deed records, the same way that you would have filed that deed, because then there's no question that it's been done and everybody's on notice.
so you'd have your attorney do that for you.
Correct.
Okay. And then we have some more questions. Amanda, is that your hand up for these others? Because let's see.
I just messaged you privately about one of them. I'm not
Okay.
sure.
Okay.
But the rest are, in for everyone. But I can
Okay.
read them or you can read them, either one.
That's good, because I know that one says here that what's the most reliable way to pass on an estate? Is it wills, trust? And we've kind of talked about that. And what is probate? I think we've answered that. What is probate? And if we do have more questions on that at the end, we'll come back to probate. But I think you've given us a lot of good information on probate and what is that. This is a good question. Can the beneficiaries, adult children, be the witness and executor of a self-made will? Let's just say I decide to make my will with LegalZoom, and I make my son the executor of our estate, and I have him sign off on everything and as the witness and etc. And how's that going to all work out for me?
Yeah, the devisee can definitely be named as the executor or trustee or anything like that, but they cannot be a witness to the will. The witnesses in Texas requires 2 witnesses for a will to be self-proven, meaning you can have the hearing in front of the judge without calling in witnesses about who signed it and when they signed it. But the witnesses cannot be someone who is taking under the will.
Okay, good information there. And then somebody else asked, does a handwritten will work? If I just say I leave everything to my son, bam, I sign it, and that's done.
It does. So the law in Texas is either you have a handwritten will, which is called a holographic will, and the whole thing has to be in your handwriting from the beginning to the end. There's no typing, there's no form. The whole thing has to be in your handwriting. And if it's in your handwriting and it's signed by you, then that is a valid will in Texas. Typically, if it's not witnessed and notarized, then you would have the person who's probating the will would have to bring in some witnesses to testify that that's your handwriting, that's your signature, things like that. The other kind of will is what you normally see if you go to an attorney, is a typed will with 2 witnesses' signatures and a notary's signature to make it self-proven. That, on the other hand, if there is any handwriting on it or any interlineation on it, that's typically ignored. So you can't, it's either all in your handwriting or it's all typed and signed by you. If you kind of try to make margin notes, those are usually disregarded.
Okay. So here's a good question. If there's no will and there is some property, it's not real property, it's personal property. For example, a car that needs to be transferred to one of the beneficiaries, and there are creditors. What can the beneficiaries do? How can they handle that? Will they have to go to court, and etc.?
Yeah, I mean, if there's no will, then the only way really you're going to be able to, well, there are some kind of smaller estate provisions in Texas law. One is called a small estate affidavit. And that's basically where you provide information to the court about the family history of the person. You state, and it's a verified under oath document, that there's no will. You have to state that there's, basically no creditors, and basically state what the assets are, and the total value of the assets has to be, I think, under $50,000. And if all of those things are true, you can file the small estate affidavit, and you need 2 disinterested people to verify that all that, the family history information is correct. And it basically says this person died, here were the assets, no creditors, and here's the family history. So here's who the heirs are, and here's what they get under the, here's their percentage of the estate. And if all of those things are true, you can file a small estate affidavit, but that's still going to cost some money. There's still some filing fee, and typically there's, there are forms out there on the internet which you can use, but sometimes they're not always correct. So if you're going to a lawyer, you're still going to incur some expense with that. Sometimes, really, to answer that specific question, it's just not worth it to open an estate. If someone dies and maybe a lot of their assets have passed outside of probate and there's no real property, and mainly maybe there's just a car and maybe there's money owed on the car, or there's money owed to other creditors, and those creditors are kind of, active and kind of seem to be seeking, they want to be paid. Sometimes it just doesn't make financial sense for the heirs of that person to go hire an attorney and open an estate and spend the money and the time to do that if they're not going to be, receiving anything, because the heirs always get paid last. The administrative expense of the estate gets paid first, taxes get paid if there's any taxes owed, creditors get paid, and the heirs are always last. So, sometimes the advice that I give people is, well, just let the car finance company come take the car. And if there's no real property, then it's really not. And sometimes even there's a small amount of money in a bank account and it's not payable on death. So the heirs, the bank won't really deal with them. And if there's $1,000 in the bank and all you're trying to get is $1,000, then it really doesn't make financial sense to spend a few $1,000s dealing with all the things you have to deal with on an estate to get 1,000. So, it always just depends on the individual situation, but sometimes the answer is it just doesn't make financial sense to open an estate. And why would you want to become the administrator and have to deal with creditors and all of that if there's not going to be enough money to pay the creditors?
Right. And sometimes I have seen that where people do that because it isn't worth it. And they're just ready to just walk away, close it out and not deal with it. So I also want to point out, because you and I both have mentioned real property. And so I want to explain to everyone what we mean when we say real property. It sounds like we're saying, it's tangible, we can touch it, but that's not it. Real property has a definition that's very important to know.
Right. So, and the importance of this comes in really more when there's no will. When there's no will, and this is one of the things that I know was on your list, Liz, it's called somebody dying intestate, meaning not testate, meaning no will. So intestate or intestacy just means that there's no will. So when there's no will, how do you know what happens with the assets? Well, there are statutes in Texas in the estates code that cover all of that. And there's really a chart. The chart tells you exactly what, relative gets what. And to read that chart, you need to know a couple of things. You need to know whether the person was married or not. You need to know whether the person had children or not. And then you need to know the nature of the assets of the property to determine where they fit on that chart. There are basically in the world of probate, two kinds of property, whether it's personal property or real property. Real property just means real estate. And anything that's treated under the law as real estate, which is, obviously usually land, your home. I think if you had like a trailer at a trailer park, the land would be real property, but the trailer may or may not be attached to that property as real property. That everything that's not real property is personal property. Personal property is your stuff, your clothes, your furniture, your dishes, your money and your accounts, your investments, cars, vehicles, everything that's not land pretty much is personal property. And so determining on that chart, was the person married? Did they have kids? Is the property you're talking about real property or personal property? And then the other piece to that puzzle is whether the property is community property or separate property. And that has to do with, if you're married, you might have community property, which means both spouses own it, or you may have separate property, which means only one spouse owns it. And then you plug all of those factors into the chart and it tells you how the estate gets distributed.
Okay. We have some other questions here. I know you're seeing them, Amanda, and you sent me one that someone has asked, and it's a really detailed question. So I think if we have room at time at the end, we can come back and really talk about what this detailed question about a medical trust and setting up a trust for, you know, a child that may not have stability and be able to handle an inheritance. And so we'll come back to that because that's pretty detailed. Somebody also asked this, and this I think leads to that, maybe an answer to that question, is how much does it typically cost? Let's just say, Mr. Klevenhagen, I call you and say, I want to get my estate in order and I don't have a lot of assets. I have a house, I have a car that's paid for, I have some investments, a few stocks, a 401k, and I want to get this all set up so that there's no problem for my children. What are we looking at in terms of cost? And I know that's difficult because I'm not asking you specifics, but just give us a range of what that would be.
So the three basic, what I would call estate planning documents that most people, in my opinion, should have are a will, a durable power of attorney, and a medical power of attorney. A medical power of attorney covers your medical care. That's pretty self-explanatory. A durable power of attorney covers everything on your behalf that's not medical. So your business affairs, your insurance affairs, your paying your bills, dealing with your bank accounts. And the power of attorney is a document that you sign designating a person or persons to make decisions on your behalf if you're unable to. So those are the powers of attorney.
And just, sorry to interrupt, just real quickly, the powers of attorney come into play while you're still living. But once you have passed away, the powers of attorney mean nothing, right? That's
correct. Once somebody dies, the power of attorney is completely ineffectual. It's as if it never existed. But to answer the cost question, so it kind of depends on, you know, what people want, but usually, and then it depends on your estate and, you know, what all is going to be included in the will, but just kind of basic, simple will. People don't really need trusts, or, you know, people who don't really need trusts or anything, and they just want to do the powers of attorney and the wills. I mean, I usually charge, you know, somewhere between, I usually charge about $1,600 for a husband and wife if their wills are basically kind of the same, which normally they are, kind of mirror images of each other, and they're just simple wills with the powers of attorney. I usually charge about $1,600. You know, if you're starting to get into trusts and things like that, it's just a little more time involved, so the cost can kind of go up from there. But I think that's, you know, I think I'm probably average on that. I'm probably not the least expensive, and I'm certainly not the most expensive. So, and what I like to include for that is, you know, obviously kind of a consultation, you know, in person, over the phone, Zoom, whatever, and just kind of get a feel for the needs of what I think the potential client may have. And then I get the information, I draft the documents, and then I have the clients come into my office and we sit down and we do a formal signing with the witnesses and everything like that. So there's no question that everything was executed properly, and that, you know, witnesses are available to testify about that if somebody should, you know, raise some question about the validity of the will later on.
I think it's important, you know, like you say, to look at that range. And like you said, you're not the least expensive nor the most expensive. That's a nice middle of the road. Because I have attorneys that I work with to try to find out the best resources for anybody that I know in this world. I see those. I see it ranging anywhere from, you know, $1,200 to $3,000. So it's just a wide variety there. what I always suggest people that they do, to anyone who asks me about it, I suggest that they call the attorney that they're thinking of using and have a conversation, a 10-minute conversation, or whatever it is that you think is the right time frame, to just kind of get a feel if that's the person they want to work with. And so is that something you do if someone calls you, and I call you today and say, hey, can you just tell me the steps I need to take and everything, and then I get a comfort level with you. I kind of interview you and you interview me to see if we want to work together.
Yeah, absolutely. I mean, that's how it's normally done. So.
And there's no charge for that if I call you and we just have a little 15-minute conversation deciding.
Correct.
Okay, perfect. Another question that's on here, which is really important. Let's see if there are any other ones. Let me ask just real quick. I think we've answered some of them about the difference between a handwritten will and one done through a lawyer, one that's done online. This, I think, is very important in our senior world, is if you have a retirement account and you don't have a beneficiary, you never named one. Let's just say it's me. I've got these retirement accounts. I've never put a beneficiary on there. And now I've been diagnosed with dementia. So I don't have a will. I don't have anything. What does that look like?
So if there's no designated beneficiary, then usually by operation of law, or maybe even in the contract that you sign whenever you opened up the account, it's going to say typically that it's going to be paid to your estate. So that would be a situation where, the family or whoever the heirs would likely open up an administration and then deal with that financial institution to receive those funds being paid into the estate. And then, they would be distributed in accordance with whatever the descent and distribution chart says. Now, you can designate as a beneficiary your estate. If you want your estate to control how those, retirement funds or whatever the account may be, you can make your estate the designated beneficiary. You can also make a trust the designated beneficiary, whether that's an existing trust or a trust that gets created in your will. Now, typically, though, it's legally, it's sometimes better to keep those assets being non-probate assets, because if there is a creditor out there, the creditor typically can't get to those kind of assets, because they go directly to the person that you've designated as opposed to coming through your estate. And so, you typically don't want to make an asset that's otherwise protected from creditors exposed to creditors. So, it's usually not preferable to bring something into your estate that otherwise is not coming through your estate. But you can designate your estate or a trust, or but if no beneficiary is designated, typically it's going to come to your estate, whatever that looks like, whether you have a will or not.
Okay, and that makes perfect sense. So that you don't want to do it that way. If it goes to the estate, like you say, if I just have it on there that my son is the beneficiary, and then my husband passes away, I pass away, and then he doesn't have to deal with that estate part of it.
Right.
It just automatically goes to him.
Right. He sends a death certificate. Usually you send a death certificate. They may have some short form for you to fill out, and then they provide you the asset.
So in all of this, everything, and again, anybody who's been to my seminars knows that I talk about this, that my goal is to arm you with information so that when it comes time to make decisions, you know how to do that. You have a lot of options. So I want you to always have options when you're making these decisions. And it looks like you have options to handle everything beforehand and make sure that everything is taken care of and all your I's are dotted and T's are crossed. And then you don't even have to think about it. And it also saves your family. But going back to the powers of attorney, it can save you as far as what's going on with you. And we didn't really touch much, give too much information. I'd like to give a little bit more on a durable power of attorney, a medical power of attorney, and then also your gosh, I can't think of it. I'm having my senior moment where you say what you want. What's it called when you tell what you want to happen to you medically?
Oh, physician's directive.
Thank you. Goodness,
Okay.
your medical directive.
Yeah.
Could not think of it for anything, and I do this all the time. So those three things are extremely important. And again, those things have to do with you while you're still alive.
Right.
So if you could just kind of touch on durable, medical, and then your directives.
So durable power of attorney, like we talked about before, it covers everything that's non-medical. So business, running a business, dealing with your finances, paying your bills, dealing with your insurance, things like that. And what the power of attorney physically is a document that you sign. And in that document, you designate a person or people to make decisions. You give them the legal authority to make decisions on your behalf. And there's actually a choice in that document where you can make the power of attorney become effective immediately upon you signing it, so that that person could literally take that document and go to the bank and withdraw all your money. Or you make it become effective only upon your disability. And there's a short definition of disability, and I think it might require a physician's signature stating that that you're not capable of managing your own affairs. So obviously, the person or people that you're designating to be your agent to take care of your business needs to be someone that you trust with everything. And then you make a decision, and there's pros and cons of both about whether you want it to become effective immediately or whether you want it to become effective, if you become disabled. So, and there's a whole list of powers or kind of authority, different powers of authority that you grant to that person. And you can do specific ones individually, splitting all those things out: banking, bill pay, insurance. Now we have one for online passwords and accounts. Or you can, which is what most people do, they just initial the one that says everything above. So that's the durable power of attorney. You designate someone to basically take care of your business.
Should I have an alternate for that? I'm sorry to interrupt.
Yeah.
Should I have an alternate? And what does that look like?
Usually you have a designated person, and then, well, sometimes people do co-agents. That kind of comes with its own set of issues that can be discussed, but you have the ability in that document to designate one person, and then if that person can't do it or won't do it, another person and another person, however many you want to go down the line. You also have the ability to designate more than one person, and if you do that, to do it at the same time. And if you do that, then you have the ability in that document to say, okay, I've designated, my 3 kids to be my agent. And then you put in that document either for them to take any action under this power of attorney, they all have to be in agreement. It has to be unanimous. Or you can say majority rules, at least 2 out of 3 have to make the decision. Or you can say they can all do it independently. So any one of the 3 of them can go around taking care of my business. And there's a whole discussion we can have on why you may or may not want to do that. But so that's the durable power of attorney. Medical power of attorney obviously covers medical treatment, and that only kicks in if you are unable to communicate with your doctors what you want. So it's not like, okay, I've designated my son to be my medical power of attorney, so now he calls the shots and he tells the doctor, whether I want to get a surgery or not. That's not how it works. It only applies, and that person that you've designated only gets to make the decision if you are unable to communicate with your doctors what you want regarding your health care. And then the way I do it, I typically, unless somebody doesn't want it, I include the directive to physicians, the directive in the medical power of attorney, so there's no question about what you want. The directive to physicians is where you tell your doctors and your healthcare providers, you know, in a nutshell, whether you want, you know, all possible medical care to keep, you know, keep you alive, depending on what your medical condition may be. And that's typically broken down into two different descriptions, and there's definitions in the actual document of these conditions. One of them is called an irreversible condition, and one of them is called, let's see, irreversible condition and terminal condition. An irreversible condition would be, for instance, you know, if somebody was brain dead and they're being kept alive by a breathing machine, but they're not going to die. They don't have terminal cancer. They don't, you know, have some condition that's going to cause them to die. They just, you know, their brain is not functioning to where it can keep their body alive with breathing and heart beating and things like that. So they're on a machine. So that would be an irreversible condition. And then you have the ability to initial one of two choices. If I'm in this condition, either I want the doctors and the hospitals to provide all possible medical care to keep me alive as long as possible, or I want the doctors and hospitals to discontinue medical treatment that keeps me alive and only provide medical treatment that will keep me comfortable, you know, until I pass away. And those are, you know, that's a decision that you can make and you can designate and take that burden off of the person that you're designating to be your medical agent. And again, that only kicks in if you are unable to communicate your wishes to your doctor. So it's not like, okay, and so the other condition would be a terminal condition, which would be, you know, maybe a bad form of cancer. And the doctors say, okay, and I think the definition is it's terminal condition is a condition that you are expected to die within 6 months. And so if the doctor says, well, you know, you have cancer here and there, we can do certain treatments, but, you know, my opinion is that, you know, you probably have less than 6 months before you pass away, then that's a terminal condition. And, you know, it's just something that there's not going to be medical treatment for to cure. And so you designate the same thing, the same two choices under that condition. One, I want all possible medical treatment to keep me alive as long as possible. Or two, I want medical treatment to be stopped except to the extent to keep me comfortable. But again, so it's a directive, an order that you're giving to your doctors, and you're telling your doctors, this is what I want. But again, that only kicks in if you're unable to communicate what you want. So it's not like, you know, you sign a terminal condition and say, well, I want all medical treatment to be stopped. It's not like if you're still communicating with your doctors that the doctor is going to say, oh, well, you said no more medical treatment. That's not how it works. It's only if you are unable to communicate. And it, you know, anyone that you designate as your medical agent with authority to make decisions, it's a good idea that you visit with that person and make sure that person understands what your wishes are. But then you can kind of double that up and take it out of that person's, you know, decision making by making this physician's directive where you're calling the shot and you're telling the doctor, this is what I want under these conditions. If I'm unable to talk to you about it, doc, this is what I want. And that's the reason I put that physician's directive in the same document as the medical power of attorney. So there's no question that it's all right there together and it's all communicated to the doctors who are taking care of you.
That makes good sense. And let's see, I think we're out of questions over here on the written questions. Anyone has written any? Does anybody else have any other questions? If you do, raise your hand, or you can unmute and just kind of blurt it out if you want to do that. I think we've touched pretty much on everything that I wanted to touch on. If there's anything else, anyone has questions. Amy, is that you? Did you raise your hand?
Yeah.
Okay, yeah.
I had a question about once you have the diagnosis of dementia, are you able to make these beneficiary decisions or estate planning decisions?
That's a great question. And that's something that gets litigated over every day in the probate courts. So there is a legal standard that a person needs to, have the mental capacity required to understand, and there's some legal terms that I don't need to throw out, but basically, you basically have to understand what you're doing, what you're signing, and the effect of it, whether that's a power of attorney or a will or any kind of legal document like that, where you're granting someone authority to do something. And, it is an area that gets a lot of litigation, because a lot of times people are, doing these documents at a time, maybe when they've received a diagnosis of, something that they're concerned in, either maybe the short term or medium term or long term, that they're going to be, getting to a position where mentally they're not, understanding everything that's going on. And so that's part of the reason for the witnesses on a will, and part of the reason for the power of attorney and the medical power, the durable power of attorney and the medical power of attorney. Typically, sometimes they have witnesses, but usually it's just a notary that's required. But, I always make sure that I keep my notary book whenever I notarize something for, a will or a power of attorney. And I go through a very formal signing process of visiting with the person. And another thing is, if I'm doing a will for a husband and a wife, I will do the signing with them one-on-one. I will kick the other spouse out of the conference room, and just so that it's very, it might seem a little silly, but I want it to be very formal. And you ask questions of the person before the witness, while the witnesses are there in front of the witnesses. You understand what you're doing. You have come to me and asked me to prepare this document for you. No one is forcing you to do this. No one else has asked you to do this. You understand that the will basically does this, this, and this is your sole decision. And, you're not on any medication today that would prevent you from understanding what's going on here. And so there's really no kind of bright line test where that could never be challenged. It could always be challenged by someone, but it's just a matter of trying to, have evidence to respond to that. And, if somebody challenged a will that I did, I would probably be a witness in that case. And I would be asked questions like, well, did the daughter call you and set up this meeting, or did the mom who just died call you and set up? How did they get to your office? Were they driven? Did they come themselves? Did you meet with this person alone? Did you ask this person why they were, doing this? Did they, in your opinion, did they understand it? Did they seem to know, what they were trying to accomplish with the will and the reasons for it and things like that? So it's kind of a continuum of evidence. And just because somebody goes to a doctor and receives a diagnosis of dementia, that doesn't automatically mean that they're not mentally capable of executing a will or a power of attorney. It certainly raises a question. And at that point, if somebody's challenging a document, once there's a diagnosis, then there's likely to be doctors getting involved and people taking testimony from doctors. And was it a mild case? Was it a moderate case? Did you, did you give any, because there are mental status exams that doctors can give to kind of test somebody's recall and what kind of the state of their dementia or their mental capacity is. And so it's all just a continuum of evidence on one side or the other. And then ultimately, either the judge or a jury is going to decide, if that's the issue in the case, whether the person had the legally required mental capacity to execute that document.
Okay,
That's a
Thank
very
you.
long answer, but
that's okay. It's
hopefully
complicated situation.
hopefully that, obviously you have a much stronger case of having a will or a power of attorney that's effective if there's no diagnosis of dementia than if there is a diagnosis of dementia.
Okay.
Okay, we
Thank
have
you.
another question from Jill. You have to unmute. There you
Oh,
go.
there we go. I'm just curious, would an attorney to probate a will need to be in the same county in Texas?
Not
does that not
typically.
matter?
I mean, a side effect and a good thing of this COVID stuff is it's kind of forced the legal profession, which in my experience is notoriously slow to adopt to new technology. If any of you have ever worked at a law firm or have any experience with that, but I think there may be a few in-person hearings, but basically for the past year, all the probate courts in Harris County have been doing hearings by this very method, by Zoom. And so to answer your question, there's any lawyer that's licensed by the state bar in Texas can practice and file anything anywhere in any court, state court in Texas. So there's no requirement. As a practical matter, it probably doesn't make sense if the hearing is in person and the estate is kind of just a regular estate and there's no expertise required. Probably doesn't make sense for me to probate a will in Amarillo if I have to travel to Amarillo and charge my time to travel to Amarillo just to probate the will, right? So it's just kind of a practical concern.
How about Fort Bend County?
Yeah, I mean, I do. All the counties around Harris County are easy to do, and it's not like I'm charging people a bunch of travel time to go to Fort Bend or Montgomery or Galveston or whatever.
Okay.
Thank you.
We have another hand up, but it says you're Christina Tam, and I know you're not, so you can unmute yourself.
Is it me?
Yes, it's you.
Hi, I'm Nazima Virani. I have two questions. So the first part of my question is, let's just say I create a will, and then after a few months, if I want to make any changes in the will, then how would that go?
It's a great question. So there's two things you can do. You can create an entirely new will, which a new will automatically revokes any prior will. So that would be one way to do it if you want to create a whole new will. Okay. The other way to do it is called a codicil. And that is where you just want to do like a change. Maybe you just want to change the executor, or you just want to change one provision, or you want to add a specific bequest. You execute. It still needs to be executed the same way the will was, with witnesses and a notary and everything. But you execute a document called a codicil. And typically, if I was doing it, I would say, paragraph, section 2, paragraph 3 is deleted and the following is inserted in its place. And then otherwise I republish and, re-verify that my will dated whatever date is still my valid will.
And then to edit the will or to update the will, it's still charged, right? Like you still charge for editing the will.
Yeah, I mean, it's, additional time. It wouldn't be as much if it was just a codicil. It wouldn't be as much as, redoing the will. But yeah, there would be some charge for that.
And is there any limitations to number of times you can edit your will in a year or anything like that?
There's not.
Right. Thank you for that.
Mm-hmm.
And my second part of question is, like, let's just say you have a will, and then after you make a will, let's just say after a few days, something happens. So what's the right way to let your family know about your will and way to keep that?
Yeah, that's a great question too. In what I would call the old days, lawyers used to keep the original will, and the big law firms had these giant vaults for documents, and it just became kind of impractical to do that, and nobody has the space really to do that. So now most lawyers that do wills, you come into my office, we do the signing with the witnesses and everything. Before it's stapled, I make copies of it, I scan it, I make some electronic, some PDF files of it, I email those to you. We make a number of copies. Usually we would recommend an extra copy for you, and then a copy for, at least one copy for the person that's named as the executor, or if it's a power of attorney, the person who's named as the agent. And then we staple the original, and we try everything we can to never unstaple the original, because you don't want someone trying to say that, oh, well, this page was inserted later or wasn't a part of the original will. Now, my wills I have people initial at the bottom of each page, but the same thing with the power of attorney. You want to try to keep that original document, and you only want one original, because I've had litigation over this too. Somebody thought they were doing it was a good idea to sign 2 or 3 copies of the will, even though it's the same will. That creates a nightmare, because you can only have one valid will at a time. So I make those copies, then we staple it, we keep it stapled. You have the electronic copy if you need to email it, and then you find a safe place to keep it. Either in like a safe deposit box at a bank, or in a safe at home, or a file cabinet where you keep important papers at home. Now, there is another option with the will, and it's an option that's available in every county in the state of Texas. You can actually deposit your original will with the county clerk. I think they charge you $5, and I do this for clients if they want to do it. And you go to the county clerk and you give them the original will, and you say, this is the original will. And then you write on the little form that they have, the people that you are designating that would have access to that document. And so it would be yourself, usually your lawyer, and the person that you've designated as the executor, maybe the backup as well. And then because it's important when you're probating a will to have the original. You can probate a copy, but it's more involved. So you want to have the original will, the one with the actual ink on it that was signed by you, signed by the witnesses, and signed by the notary. So you can have the county clerk hold on to that, and they give it like a filing number, and you have that filing number. And then, like I said, the people who are designated on there have the ability to go access it and get it out, or convert it to be filed. And then because it's very important to have the original filed when you're probating it. So options really are for you to keep it in a safe place or to deposit it with the county clerk. But either way, you want to communicate that information to the person or the people that you've designated as the executor to be in charge, so they know where to go find it.
And what is your answer when there is a conflict between the names on the beneficiary? Let's just say my bank account has a different name as a beneficiary, but in my will, I made a separate person which I might not be aware of. So when there's a conflict between the names of beneficiary, do you go with what's written in the will, or you go what's in the bank account?
If it's a non-probate asset and you have designated an account like payable on death, then it goes by the non-probate asset portion. It doesn't even make it to the estate, so it's not controlled by the will. In fact, that I've seen that happen before. Somebody can designate in their will, I want this account to go to Jim. But if you go to the bank and at the bank you said, I want it to go to Jane, it goes to Jane. Even if you say, I want it to go somewhere in the will, if you have designated somebody in that non-probate way, then that controls.
So your suggestion is to keep the same names in the account and the will so that it doesn't.
Well, you just don't have to put it in the will.
Put it
If it's designated at the bank, then you don't have to put it in the will.
But bank doesn't ask you, right, that the person is gone now, they just give it straight to your beneficiary.
Correct. If there is a person designated, it goes to them.
So what if a beneficiary is a minor? Like I have two.
I think we covered that earlier, so we might need to, we're really out of time now, and we have one more question. So we did cover that earlier about what to do with minors. So when you can get the recording and come back to it.
Yes, thank you very much.
Okay, thank you so much. And now we have Bob.
Uh,
Last question we're going to be able to take.
yeah. Hi, thank you. I hope this is quick. Am I overdriving the mic, I guess? My question is, you mentioned being able to file a copy with the county. Now, if as
Well,
the
not
other
a
lady-
copy, file the original with the county, not a copy, the original.
I'm sorry. Sorry, I'm a little too loose with the English language. I'm not used to the speaker, I guess. Anyways, my quick question. Next year I make a change or I decide to make a new will. What happens to the first one I filed?
You go pull it. You would be, you or, your lawyer or whoever you put would have access. You would go just retrieve it and then they would give it back and then it would be, they don't have it anymore and you would give them a new one.
Okay, so that just reinforces one will. That's all.
Correct.
Okay, great. Thank you.
Thank you. Anybody else have any other questions, you can always send them to Christina and then she can get with me and, we can make sure they get answered. There are just different ways that we can do that, but we'll be on next month with a different topic and we'll be sending that out. And if there aren't any more other questions that haven't been answered, then we are finished. I always give my little public service announcement real quick that says where you should keep your powers of attorney and your medical directive and all those things. And, when first responders go into a home because something has happened, they always go immediately to the refrigerator to look and see if they're there. So that's a great place for you to keep your emergency numbers or whatever and your power of attorney and all of that information. It's a great place to keep that. And actually, if your refrigerator is stainless steel and you can't use a magnet on it, you can put it inside the freezer and they will open that and look at the freezer and the fridge and see if anything's in there when they look for those documents. So that's just one little tip. So Amanda, did you have anything else?
Yes. So thank you so much for coming. We have an upcoming seminar on August 20th called Estate Planning, How to Avoid Forced Guardianship. And you can register for that and other events on our webpage at www.fortbend.lib.tx.us under the Events tab. Thank you so much for coming to this event and have a wonderful weekend.
Thanks, everybody.
Thank you so much.
Oh, yes. And if you want the recording and you want a different email than the one that you registered with, just put it in the chat and I'll get it added to it.
Thank you.
Thank you.